Good afternoon, and it's great to be back with all of you. Hoping that October has been treating you well thus far. It was an absolutely peak fall weekend that we just were able to share in the downstate New York region and Confident Points north and west. And for those of you tuning in elsewhere, we are in the middle of a beautiful season and really glad that you can take time to be with us. And today's agenda is pretty packed. So if Kathy would go to the next slide, I'll walk the group through it and let you know what we intend to cover today. First, I will touch on healthcare updates, and I'll be pretty brief today because I want to make sure there's room for time for our attorneys who follow me. Tom Iran, who has presented before this group a number of times over and is a key leader in our labor and employment practice, is here to discuss the presentation that recently the National Labor Relations Board General Counsel Jennifer Abruzzo delivered. Then Shannon Knapp will be with us to talk about Cybersecurity Awareness Month and practical tips. October is not just peak fall weather, it is also time to tune up on cybersecurity. So Shannon, thank you in advance. Dustin Dursino is back with us to cover cannabis and personal cultivation of medical cannabis specifically. And then Travis Tellerico from Rochester, also back with us, will be covering expanded information blocking rules that earlier this month went into effect, which has a lot of implications. Kathy, you would go forward, I'd appreciate it. So what we're most concerned about is that the public health emergency continues. And of course, that means that all of the relaxations that we've seen emanating from the federal level remain in effect. It has always been the case that we would get a 90-day warning, and we have not gotten that as of yet for any further on renewal. Instead, we got a renewal by Health and Human Services earlier this month that indicates the public health emergency continues. And there are reasons why. What we see happening are new subvariants and new risks. There is the BQ1 and BQ1.1. And Dr. Fauci was recently, on the record about some of his concerns he has with it. We also know that the XBB variant is circulating globally. And so we'll see what happens in the Northeast United States and where else you may be tuning in. We're also very mindful of the fact that vaccines have been authorized for kids as young as 5. These are the boosters specifically that adults had access to first. So there'll be more to come for sure. And as the issues percolate over the course of the fall into the winter, we'll be back to give you further updates. And then there's only one other thing I'd like to cover today on the next slide. And that'll be, thank you, Kathy, the New York Healthcare Mental Hygiene Worker Bonus Program. I've spoken to you about this a number of times before. And as of October 31st, the second vesting period closes. So those of you who are involved in interacting with that program, now's the time to continue working on that. And we at Bond certainly can be supportive. And those with educational ties and otherwise who are waiting on the proverbial sidelines to be part of this program per the guidance we had received earlier, those sidelines are no longer the place to be because the program opened to education as of earlier this month, and essentially vesting periods 1 and 2 are now open for filing, and we can help again with that. So again, without further ado, let me then turn this over to others who are here to present. The first being Tom Iran, who's again a leader in our firm who is someone with tremendous experience in labor and employment matters, and who was able to screen a recent presentation by the NLRB's General Counsel and has observations that he thought would be useful for this audience. So Tom, please go ahead, and thank you so much for taking the time to be with us.
Thanks, Gabe. I appreciate that introduction. Good afternoon, everyone. I had the opportunity to attend a program sponsored by the College of Labor and Employment Lawyers last week, which featured in person NLRB General Counsel Jennifer Abrazo and two board members, Gwen Wilcox and Dave Prouty. You probably know that the General Counsel has been very active speaking in a number of different forums and writing on topics that are relevant both to unionized employers and non-unionized employers. And so I was interested to hear from her in person, firsthand. I can tell you, Gabe, that she's unabashed in her belief that the law, the National Labor Relations Act, in key respects has been misinterpreted for the last 50 years, and she is going to seek dramatic changes to the law. Early in her remarks, she said that she was a, quote, taking a, quote, pro-worker position. I think that's a bit of a misstatement. I think that while she disavows a pro-union position, in fact, the policies and legal changes that she's presenting are, in fact, pro-union. The clearest example of that I can give you was in the question and answer segment when my partner, Ray Pascucci, asked the General Counsel if she agreed that a secret ballot election was the preferred mechanism to determine whether employees wanted to be represented by a union. Now, I think of that as a core principle in the National Labor Relations Act, but the General Counsel disagreed. Her position is that when a union demands recognition, the employer should be obligated to voluntarily recognize the union as the exclusive representative and bargain a contract, unless the employer can show, quote, good faith doubt as to the union's claim of majority status. Let's understand what that means. The law would create a presumption that the union is the representative and that the employees prefer the union based on signed cards versus an election. And the law would put a burden on the employer to present evidence of misconduct, misrepresentation, some doubt that the union's claim was not legitimate, and only then would the process proceed to an election. In the back and forth that these statements sparked, the General Counsel went so far as to say, quote, don't waste our time in pursuing an election if you don't have a good faith doubt. She was also very critical of any mandatory meeting, including one-on-one meetings between a supervisor and an employee, in which the employer representative was expressing views on unionization. Her position is those communications, those meetings are inherently coercive and therefore unlawful. Now, there is no current law that supports that view, but it is her philosophy that there is this overwhelming coercion that requires the NLRB to check conduct actions by an employer. This spills over into the work rule area, right? And we've seen this back and forth for 10 or 15 years, but she was, quote, highly critical of broad work rules that seek to regulate employee conduct. And she also talked extensively about creative remedies that she and her administration are pursuing for violations of the Act. In addition to the eye-opening, and I would call it radical views, what takeaways can we identify from her comments here and in other public statements? I can come up with 4 of them for you. The first one is basically steel yourself. We're facing a long period of unsettled law on numerous fundamental issues. Issues like who is an employee? When is a contract employee, a gig employee, a temporary employee, a quote unquote employee under the Act, subject to the protection of the Act? Under what circumstances may an employer lawfully address employees about the employer's view on unionization and union activity? And of course, the fundamental question: under what circumstances would the general counsel allow for an election, as opposed to requiring voluntary recognition? We know that the general counsel's interpretations become enforcement actions, which are followed by hearings and board decisions and ultimately appeals, a process that will take years to play out, and one that could be cut short or extended depending on the results of the presidential election in 2024. But we need to steel ourselves. This is a long and bumpy road ahead. I think the second takeaway is trying to understand why the general counsel is being so vocal on these views. What's the strategy behind this publicity campaign? I can see two. I think there's an obvious one, that she knows by talking about her positions, she's going to influence some employers in how they react. That she's going to encourage or cause employers to change their behavior to attempt to limit the risk. No one wants to be the test case on these scenarios, so employers will react based on her comments, even though they're not currently the law. I think the second purpose that she serves here is a little bit more obscure, and it has to do with what happens when the law changes. Whenever the board decides a case through adjudication, it has to wrestle with the question, do we apply this new rule prospectively or retroactively? And the test really for retroactive application is whether that application would work a manifest injustice. And I think that by making her views widely known, the general counsel is laying the groundwork to argue for retroactive decisions, retroactive application of the decisions. I can envision her brief that says employers knew or should have known that the result was being pursued by the general counsel, and now the employer cannot claim an injustice when that result is finally achieved. So I think she's laying the groundwork here for the impact into the future. Third takeaway is let's focus on what preparations we can take. The actions that employers take today are going to be the subject of NLRB scrutiny tomorrow. So it makes sense to evaluate current practices and policies with an eye toward the potential legal changes. Can we mitigate some of this risk? And let me give you just one example. We know that the general counsel intends to challenge the use of captive audience meetings that arise in the context of a union organizing campaign. So for a non-union employer, many of you use communication techniques such as a town hall meeting for a large group to talk about your business activities and successes. Or you use smaller groups, stand-up meetings in a department, or one-on-one supervisions. Using those kinds of communication techniques proactively when there's no union campaign to talk about employer policies, employer labor relations topics that are of concern to you as the employer when there's no campaign, could help provide a defense when a campaign rolls around and you use those same communication techniques to talk about those campaign issues and defeat the claim that you're only talking to employees about issues related to their relationship with the business in a union campaign context. So be prepared. And the last takeaway is that if you're faced with an NLRB charge or a union organizing campaign, you have to recognize that the world has changed. You may have handled unfair labor practices in the past or a union campaign in the past, but if you get one tomorrow, you really need to take a different, fresh look at it. With respect to charges, the General Counsel's focus on complete relief makes the charge much more difficult to resolve at the regional level. But we know that in the past, the majority of cases were either settled or withdrawn at the regional level, and that's just becoming much more difficult to do now. And this administration is ramping up the use of the 10J injunction, which is a technique that it has to go into federal court and pursue interim immediate relief. The courts tend to be highly deferential to the board on the 10J injunctions. We successfully defended one recently, which would have given the union significant leverage at the bargaining table. But those victories are difficult and few and far between. So in handling an NLRB unfair labor practice case, you have to be mindful of how does this situation fit with the board's or the General Counsel's intentions to pursue 10Js. And likewise with the union campaign. If you've had a campaign in the past, every page of that playbook that you followed needs to be reevaluated, scrutinized, and reconsidered in light of the changed environment that we're in. Frankly, the world has changed. Those are some of the thoughts that I have after listening to the General Counsel. Gabe, I appreciate your giving me the podium this afternoon to talk to the folks. Thanks very much.
Of course, Tom, and grateful that you could share your observations with this group. Once again, Tom Miron, who's the chair of our firm's Labor and Employment Law Department. And Tom, of course, we look forward to hearing more from you as these issues continue to develop. I want now to give an opportunity to Shannon Knapp to make sure that all of us are attuned to cybersecurity awareness in this Cybersecurity Awareness Month. Just because it's this month where we're focused on it doesn't mean it's the only time to really ensure that we have our attention on these important matters. Shannon is in great position to brief us all. She not only has been with the firm working on data privacy issues for clients, and she also happens to hold a certified information privacy professional credential, which makes her all the more versed on issues of data privacy and in position to brief all of us. So Shannon, the floor is yours. Thank you for coming back on the program, and we're looking forward to hearing about what we should be paying attention to. Thank you.
Thanks for that intro, Gabe. So as Gabe mentioned, it is Cybersecurity Awareness Month, all of October, and we want to take this opportunity to provide some quick tips to prevent, prepare for, and navigate a data breach, which as of now and probably for the foreseeable future is one of the most significant risks to an organization. And as a result, we want to provide some helpful tips and different information so organizations are prepared and ready in an instance notice. So for the first thing, we want to make sure that organizations are striking a balance between prevention and planning. So oftentimes organizations on the forefront of their mind think about prevention, where they're in IT personnel, making sure they have encryption and other technology in place, but planning for a data breach is also very important. And one of the best ways to do this is through an incident response plan. And an incident response plan is very important because if your prevention measures fail, you want to make sure you have a plan in place to respond to a data breach, as oftentimes time is of the essence in these situations. And your incident response plan needs to be flexible. You don't want it to be rigid or not be able to flow with the different types of breaches that may occur, because every data breach is different depending on the type of information that was potentially compromised, the type of data breach, whether it's a phishing scam or a ransomware attack, or an unauthorized disclosure or something along those lines. So making sure you have a flexible incident response plan is really important, and having one that's readily available to the players in the game that would be responding to the breach is also very important. And one way to test your incident response plan that's often very helpful is doing a tabletop exercise with all the necessary players, maybe once a year or every 6 months, to make sure that you have practiced and can properly respond to a data breach in a moment's notice as soon as you're notified that something is occurring. Also, the next important tip we want to provide is be responsive. As I mentioned before, if there is a data breach, you have to respond in a moment's notice, and you want to be responsive for a number of reasons. First off, oftentimes cybersecurity incidents can lead to litigation or government enforcement action, and you want to make sure you're doing all the necessary steps to protect yourself legally, but also respond to the incident and make sure that the bad actor is out of your system and things like that. You also want to make sure you're pulling in important players very early on, and this includes your IT professionals, whether that's outside parties or inside IT professionals, your legal counsel. Make sure your legal team is on notice as soon as possible, as each breach is different depending on the types of laws that it pulls in, depending on the type of data affected, and if you're a covered entity of certain sector-specific laws. And you also want to put your cybersecurity insurance carrier on notice as soon as possible to make sure that you are adequately notifying them so that you can have sufficient coverage in the event of a data breach. And early on, you also want to make sure that you're investigating the incident and preserving any evidence, that you retain forensic experts to help with getting bad actors out, but also investigating the incident and what caused it. And you want to also be wary of disclosing too much information about a data breach other than that's what's required under the law, which is why it's important to talk to your legal counsel as early as possible, because public statements can be used against you in litigation or enforcement actions. And you obviously want to provide as much information as necessary so individuals understand what had occurred, but you don't want to provide too much information. So you want to strike that balance. Also, the next important tip is to keep up to date. So as we all know, cyber criminals and threat actors continue to evolve and learn, and technology continues to evolve and get more and more sophisticated. So you want to make sure your information technology team and your infrastructure stays up to date to prevent a data breach. And this also includes a lot of different things, many of which was not standard before, but is much more standard practice now, such as encryption at rest and in transit, as well as multi-factor authentication. In certain state and federal laws now, especially if you're in a regulated industry, such as government contracting or financial institutions or healthcare institutions, require that businesses maintain such adequate safeguards under the law. You should also ensure that your outside vendors are also having such adequate safeguards in place if you're using them for employee information or for your information technology, as just a few examples. And you can do this in a number of ways, but through contractual provisions, audits, or through requests for proposals in your RFP process for new vendors is a great way to do this as well. Also, it's really important for prevention and preparation also that your organization trains your employees, contractors, and other third parties about security risks and things like that. You want to do regular phishing testing and things like that for employees, have them do security modules, things like that. And also make sure that your employees know who to contact if they feel there has been an incident so that it can be rectified as soon as possible. You also want to make sure that you review your policies and procedures at least annually to ensure that they're up to date and continue to reflect the best practices, updated technology standards, and also new legal requirements. As I mentioned a little bit earlier, a lot of data breach laws are very jurisdiction specific, depending on where the individuals affected are located, and those laws continue to change rapidly. So making sure that your policies and procedures are up to date to reflect this, but also to make sure you're not subject to any new laws is important as well. And lastly, you don't want to be dismissive of the risks associated with a data breach. Oftentimes, headlines are dominated by the large-scale data breaches that we hear about, but not necessarily smaller organizations. But data breaches could happen to anyone at any time, no matter how big or small you are. So it's important to take adequate safeguards and to make sure you have cybersecurity insurance and take some of the steps that I outlined above to protect your business and organization. And let us know if we can help in any way. And I think that's all I got, Gabe.
Shannon, thank you so much. A comprehensive overview. There's a lot for participants to chew on. And if any of that was fast, we certainly, will make sure that Shannon is available to talk with any of you offline. And B, this will not be the last time we'll be talking about cybersecurity. We'll continue to reinforce these important foundational steps around cybersecurity. So Shannon, thank you again for being with us. And I just want to take a quick moment to note, in the vein of cybersecurity, as I think I've shared with you before, I'm also involved in the work at the intersection of healthcare and cybersecurity. And one of the roles that I have outside is as a co-chair of the New York Healthcare Cyber Alliance, and Bond is supportive of that work. And there's a webinar on November 2nd at 1, which will be an opportunity to hear from Colin Ahern, who's the newly appointed Chief Cyber Officer in the state of New York, and he'll be speaking about intersectional issues concerning healthcare and cybersecurity. If you're interested in that event, please contact me offline, and I'll make sure that you have the right information. We'll be providing more formal detail in a moment as the week progresses. But for now, let me turn to our next speaker, who's going to be Dustin Dorsino, who's back once more, and we're grateful that Dustin can take the time. He is in our firm someone who's been tracking the cannabis industry very closely and guiding clients with questions. And Dustin is here to tell us about developments in the medical cannabis space. So Dustin, the floor is yours. Thank you for coming back, and we look forward to learning.
All right, thanks, Gabe, for that introduction. And yeah, I've been on this series before, talking a lot about recreational adult use cannabis and the regulations that New York State has been coming out with. And as a result of the state's focus on recreational cannabis, the medical cannabis space has sort of flown under the radar as of late, but recently on October 5th, it was announced that those who have their medical cannabis cards can start growing their own cannabis for medical purposes at their private residences. So a little bit of legislative background, as this has flown a little bit under the radar with the ramp up of license applications for recreational cannabis applicants. The OCM proposed the personal cultivation of medical cannabis regulations back in June, and they underwent a public comment period that closed at the end of July. And as I stated earlier, on October 5th, the final regulations were adopted in the state register by the Cannabis Control Board, who was in charge of approving all license applications and final regulations in New York State. And as of October 5th, medical cannabis patients can start growing their own cannabis at their apartment or their house, or where they reside for their own personal purposes. If you would go to the next slide, please, Kathy. So under these final regulations, the two separate groups of people that can grow their own medical cannabis are certified patients and certified patients designated caregivers. Both groups must be at least 21 years of age, and they have to go through a registration process with the Office of Cannabis Management to be able to grow medical cannabis. And in order to qualify as a certified patient, you must be certified by a doctor who has taken the required certification classes set forth by the Office of Cannabis Management. There are separate courses that doctors must take in order to be certified, in order to certify patients to grow their own medical cannabis. And the classes will take hours for doctors to complete. So if you are interested in becoming a medical cannabis patient, it is not as simple as just walking into your PCP's office and asking them to certify you to grow cannabis in your backyard. This requires a serious medical condition, and some examples are ALS, Parkinson's, PTSD, or any other condition at the discretion of your certified doctor. And from the time that the OCM proposed these regulations until their adoption this month, that definition of what counts as a certified medical condition has expanded quite a bit, and it allows room for those persons who don't necessarily have a serious medical condition, but still feel they would benefit from access to medical cannabis, to discuss with their certified doctor and potentially get certified as a medical cannabis patient. Designated caregivers can grow for certified patients who are either under the age of 21 or who are unable to grow medical cannabis because of a certain physical or cognitive impairment. And the caregiver can grow for up to 4 patients at one time, but only one caregiver can grow on behalf of a certified patient. So for example, if a certified patient is over the age of 21 and does not have a cognitive or physical impairment, then that certified patient cannot designate a caregiver to grow on his or her behalf and would be able to grow for his or herself. On the other hand, if there was a certified patient that was under the age of 21, there could only be one designated caregiver for that specific patient. And the fact that you are licensed as a certified patient does not prevent you from being a designated caregiver on behalf of other certified patients. Next slide, please, Kathy. And if you qualify as a certified patient, or if you are selected as a designated caregiver on behalf of a certified patient, you are legally now able to grow medical cannabis in your private residence. And what the regulations define as a private residence includes any building or structure that is designed for residential occupancy. So you could grow medical cannabis in the backyard of your house, in your apartment building. And then as long as you are occupying that space for residential purposes, primarily, you are able to grow medical cannabis so long as you're registered with the Office of Cannabis Management. However, patients and caregivers can only grow their medical cannabis where they primarily reside. So if you have a vacation house in Florida or California that you would think would be perfect to grow medical cannabis for your use in New York State, you are unable to grow there because that is not your primary residence. And the regulations also limit the extent to which certified patients and their caregivers can grow medical cannabis by limiting the amount of mature and immature plants that can be grown at one time. So any one patient is able to grow 3 immature and 3 mature plants at one time. And a cannabis plant is mature if the plant has buds and is flowering, and the buds can be observed visually. And a plant is immature if the female plant either is not flowering and does not have buds, or the buds cannot be observed by visual examination. And if you have more than one private or certified patient at a given residence, then that limit will be doubled to serve those 2 patients. So if you have 2 certified patients or 1 patient and 1 caregiver living at one private residence, then you will be able to grow up to a maximum of 6 immature and 6 mature plants at that residence. However, if you have more than 2 certified patients or caregivers at one residence, that maximum is not increasing based on the number of certified patients or caregivers past 2. So the maximum number of plants that can be grown at one residence is 12. Next slide, please, Kathy. And so this is always the least favorite slide when I talk with clients about new regulations being passed and the cannabis industry in New York expanding. But since these are regulations and the cannabis industry in New York is a heavily regulated area, there are certain things that people cannot do under these regulations. The most notable is possess more than 5 pounds of cannabis. Now, generally what would happen when you are growing medical cannabis is you would grow the plants and you would trim the cannabis off of the plant to store it for your own use or process it into cannabis-related products for your own use. And the 5 pound limit does not include the plants that you can grow up to the 3 immature and 3 mature plants at a time. So the 5 pounds of cannabis that you can possess at your private residence only includes cannabis trimmed off of the plant. Another thing that people are unable to do under these regulations is grow medical cannabis in places that are plainly visible to the public. So in order to grow cannabis at your private residence, you have to grow behind gates or enclosed doors, fences, or other barriers. And what's notable about this requirement is that it does not limit the grow to a certain number of feet away from an elementary school or a church, like recreational cannabis regulations have done in the past. They just want it out of plain sight from the public. Another thing you can't do is sell or offer to sell any medical cannabis or medical cannabis products to other people. You're only allowed to transfer up to 3 ounces of cannabis or 24 grams of concentrated cannabis only to other certified patients or designated caregivers. And even then, you are not allowed to get compensation for that transfer to other authorized patients or caregivers. And additionally, if you're a caregiver, you are not allowed to charge a certified patient for growing their medical cannabis for them, but you are able to get reimbursement for any costs or expenses incurred in the growth of the medical cannabis. Additionally, if you are a certified patient or a designated caregiver, you can process the cannabis that you grow and trim off of the plants into cannabis-related products such as gummies or tincture fluids, but there are certain specific restrictions on how you process that cannabis into cannabis-related products. And so if you have any questions about any of this information provided or recreational cannabis or the industry in general, you can feel free to reach me at my email, ddorsino@bsk.com. Thank you.
Dustin, thank you. Really important information that we're all learning. And we have a few questions that came in through the chat while you were presenting. So looking forward to having you connect with some of our audience there. And let me move to our final speaker for this afternoon. It's Travis Tallarico, who's been with us before out of our Rochester office. Who works in labor and employment and corporate litigation. I have the pleasure of working with Travis on overlaying healthcare matters, and it's good to have you back. And you're going to be telling us about information blocking and what's new there. So Travis, the floor is yours, and thank you for bringing us all up to speed.
Thanks, Gabe, and good to be back. Hello, everyone. Thank you all for tuning in today. So as Gabe alluded to today, I'm going to be presenting on an amendment of a topic that I presented on here back over the summer, and I'm going to be discussing a bit about that topic in general. So apologies for anybody that may have tuned in for when I presented on this topic last time, but felt for those that did not, it'd be helpful to include some general information about the information blocking rules under the Cures Act. But specifically, the update today is going to be related to the update in the definition of electronic health information that recently went into effect on October 6th of this year. So we can dive right into this. So again, just to provide a little bit of background for those who aren't familiar with generally what we're talking about today. So there is a portion of the Cures Act that was amended and which went into effect on April 5th of 2021, which essentially was designed with the purpose of providing patients better access to their electronic health records. So notably, as language that was included in the final rule, the goal of this was to increase transparency between healthcare providers and their patients, cut costs, improve care, and allow faster access for patients to be able to access their records. The general goal that's stated in the final rule is to bring patients to be able to see their test results and access their electronic health information essentially immediately at the same time when it's released to their doctors, and that electronic health information should be available for patients when and where they want it. So what actually is information blocking is more general context. So generally, according to the Cures Act, it is a practice that is likely to interfere with, prevent, or materially discourage access, exchange, or use of electronic health information. So who is subject to these provisions? And generally, those who this may be relevant to that are on the call would be healthcare providers. And as we can see on the slide here, I'm not going to go through and rattle off this entire quotation, but it includes essentially any and all medical providers. So ranging from large hospital networks, even down to local private practices, physicians, practitioners, pharmacies, pharmacists, essentially any covered entity under Section 30 or 340B here. And so essentially what this amendment did is it required healthcare providers to allow access for patients to get access to their electronic health information in real time. So what does this actually mean? This meant that providers were supposed to start rolling out, if they did not already have, avenues for patients to be able to access their health information electronically without, in effect, having to go and request, say, for example, copies of paper documentation of their files from their providers. And the Act didn't and still does not explicitly specify in terms of what types of mediums a provider are supposed to use, but do seem to encourage use of portals, apps, things of that nature for patients to access their health information. And just as a bit more background information here, this amendment did not require a provider to take any proactive measures to provide patients with electronic health information who had not requested it, but it's a little bit of a catch-22 here. The amendment did state that if a patient requests their electronic health information, a provider must have a system in place to be able to provide that information. And so back to the slide a few slides ago as to what is information blocking, a delay in the release of available electronic health information in response to a request might constitute an interference with information blocking, or maybe fairly obviously not having any procedures or systems in place to allow patients to grant that access in the first place. So turning to actually what the focal point of my presentation is today is what is electronic health information. And so the point of today's update is distinguishing the difference in what actually was classified as electronic health information under this amendment to the Cures Act. So prior to October 6th of this year, ONC had previously defined electronic health information as the data elements in the United States Core Data for Interoperability Standard. And so specifically what these meant, it was more of a limited category of information, as on the third bullet here: consultation notes, discharge summary notes, history and physical notes, imaging narratives, laboratory report narratives, pathology report narratives, procedure notes, and progress notes. So as of October 6th, the EHI definition was expanded, which now includes the full HIPAA electronic designated data set. So this essentially means any health information that is really in the possession of a provider. And so any health information that is transmitted by electronic media, maintained in electronic media, or transmitted or maintained in any other form or medium, with a few exceptions there. So the big takeaway from this is just knowing for providers that are implicated and covered by this rule that the category of information that is now covered and that needs to be accessible by patients has been expanded. So practically what this means might be talking to any of your EHI vendors to see actually what is being provided to patients, and if there needs to be any, working with them or reviewing some internal policies to see if patients do truly have access now to their full record. And we just have one more slide as a final note and update here. I've been keeping an eye on this over essentially since this amendment got rolled out. The initial amendment to the Cures Act did not actually specify any penalties for noncompliance for providers. And to date, there still are no sort of definitions for defined penalties other than general references to disincentives. So we all know that the federal government tends to move slowly on things. They've been moving very slowly on providing any sort of definition for penalties for noncompliance here. But this is still something, and as I've said before when talking on this topic, not something that healthcare providers should just stick their head in the sand in. Presumably, there eventually will be specific penalties that are rolled out for noncompliance. So it is something that all providers should be taking an active measure on, and making sure that their patients do have an avenue to access their healthcare records electronically.
Travis, thank you. That was very helpful, both to lay the groundwork about how we got here and then to highlight what those tuning in really need to be paying attention to, and otherwise building up awareness around. And so with that, let me just make sure that all of you have ways of contacting us. If there are questions that have come up over the course of the webinar, we're here for you. I look forward to be back with you on November 1st. And in between next week, Adam should be with you and leading the webinar. We thank you for tuning in every week. It really is our goal to make this as informative and as useful to you as we can. And we look forward to your recommendations on programming. And for now, stay safe and well, and we'll see you soon.